Welcome back, everybody, to another I'm representing myself, Your Honor. I don't care what you have to say. Episode of Lockdown 23 and 1. That's right, today's episode is a prime example of what not to say to a judge. Not to mention a plethora of other things. We're going to be learning a lot today. So let's jump right into it, ladies and gentlemen. If you're new to the channel and enjoy all things lockup and crime related, then this is absolutely where you need to be. Hit that like, subscribe, notification bell before you leave, and check out my beautifully assorted playlist with many more videos for you to start watching today. Alright, let me break down a few things before I press play. This 38-year-old defendant here is in court for assaulting a correctional officer while he was doing time for an aggravated robbery charge. And what inmates call that is tricking your time up, when you get into more trouble in prison where they have to take you back to the courtroom to give you more time added to your sentence. Your release dates push back dramatically. And you know, this is the thing, a lot of guys, when they're sentenced to like 10 years or more, this guy was sentenced to 14. So regardless of what happens in this courtroom, he's going back to prison immediately. He's just dressed in regular clothes because he's probably going to be going in front of a jury. And defendants have a choice to come out in this regular clothing because, you know, a jury could see you in your jail or prison outfit and already start leaning towards guilt. But like I said, this guy still has 4 years on his sentence for the aggravated robbery. And he thinks the sentencing today is going to be ran concurrent, which means no time added. It's just going to blend into his original sentence. But in the description of the video, it seems as though that's not going to be the case.
Mr. Jones is present before the court with counsel, Ms. Morton. Mr. Arnold's here on behalf of the state of Ohio. I've been told that there's an issue.
Your Honor, my client has indicated to me that he might want to represent himself in this matter. I just wanted to bring it to the court's attention to have the court address that issue.
All right, Mr. Jones, why don't you tell me what's going on?
I just want to represent myself. I feel like nobody's going to fight for me like I'm going to fight for myself. I've been through voir dire, I've been through jury trials. I've done all this before.
Did you go to law school?
No, I did not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor's office in Hamilton County and Warren County for how long, Mr. Arnold?
Well, if you add in military time, almost 46 years.
46 years. He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
I don't really care about none of that.
But here's the problem.
All right, first thing smoking, man. Those words should never be uttered in a courtroom to a judge, ever. I don't care about none of that, is what he said about the prosecutor's 46 military time years in service. He don't care. He rolled his eyes, man. It's Smokeville already. And that bison lining is gleaming, man. Look at that thing.
I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law.
All right.
I'm sorry?
It will be all right.
It won't be all right. I'm telling you,
It ain't no time, bro. I got 10 in, 4 left to do. I do not care at all, even a little bit. It's 3 years. It's cut and dry. What happened, happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man?
This dude's already did 10. He don't care about an extra 3-piece snack, man. He's already in laydown status.
It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you gotta try stuff in life and never know how good you might be at that.
You ever picked a jury before?
I have. I've been through mass of those. I've been through at least 7 different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. I had to do it all over again.
You realize that if you do this, you cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
And look, a lot of people, they'll do this type of stuff just so they can try to get an appeal and prolong going to prison. But I don't think that's what he's doing here. I think he really just don't care, wants to get his time or whatever the jury gives him and be on his way. He thinks it's an open and shut case, no evidence. He's just going to speak his 2 cents to the jury, hope for the best and expect the worst, man. Some people have a gift of gab like that. But like the description of the video said, I don't think the defendant knows that the judge could run it consecutive to his already in place sentence. Meaning he'll have to do that time for the aggravated robbery first, 14 years, and then begin whatever he gets today for assaulting the correctional officer. I tell you, when you're at the gate, you're about to go home after doing a 10-piece, and they were to tell me they added an extra 3 years, I'd be sick to my stomach, man. Honestly, I really would.
All right.
I'm
That's
sorry?
Cool.
It's not cool. It's you're making a huge mistake.
I mean, I made a whole bunch of them. I'm sitting in prison right now for something I ain't do, so I make a lot of mistakes. I can't live life with regret, man. Gotta do what you gotta do.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what
Ms.
I
Martin
gotta do.
does not.
I mean, that's cool. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is what I'm doing right now. I'm sorry?
That will be tested. We will see about that.
And yes, a lot of people believe that all the individuals in the courtroom are working together, sipping tea, eating scrumpets. And you know, I used to think like that too until I had one of the best court-appointed attorneys I could ever imagine. Beat multiple charges for me, and I ended up hiring him later on down the road. Just my 2 cents though, going into the courtroom, representing yourself without any kind of law degree or whatever is probably one of the biggest mistakes you could possibly do. I can assure you that, man. You might think you know a little bit about the law. You'll find out real quick that you know just about nothing.
The other problem is obviously you have a right to remain silent with you asking questions, and you're making a huge mistake.
It's added to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man. It's only 3 years. I got that.
And as long as you understand that in asking questions, in picking the jury, in everything that you do, here's the other problem. Here's the other problem. Is he in shackles?
Yes.
Okay. There's the other problem. Because you are in custody, you have shackles on. Do you want the jury to see you in shackles?
That's grounds for an appeal by itself. I realize that part. They're not supposed to let the jury see me in shackles, so I mean that's kind of like a tipsy-turvy type of thing right there. I know a little bit more than most. I ain't all the way simple, close to it, but a little bit more than most.
All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is a felony of the 3rd degree assault because of your status, the status of the alleged victim, and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
Correct.
All right. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question.
I
Are you aware of any?
question.
Are you aware of any?
I don't understand the question you're asking, sir.
Well, you're going to represent yourself and put on a defense, I assume, at
Correct.
least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand
Correct.
that?
Like impeaching a witness?
Sir, I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yes, sir.
All right. There may be possible mitigating circumstances. Do you understand that?
Huh? No, nope, I don't.
Well, I kind of do a bit. You know, there's mitigating and aggravating factors. Mitigating means minimalizing things that could play in the courtroom to give you less time during the sentencing. Then there's aggravating factors that could take place in the courtroom to give you way more time than you could ever imagine. You know, let's say you did your crime because of some racial thing or something like that. Yeah, you're going to be smoked. So mitigating means less, aggravating means more. Any attorneys in the comment section, let me know if I was about right. But for this guy to have done 10 years and he don't even know what a damn mitigating factor is, yeah, he definitely shouldn't be representing himself whatsoever.
Again, that's another reason why you need to have
3 years, man. That's
I'm sorry?
3 years. That's nothing.
Let me tell you something.
It's 3 years, Your Honor. It's a stone's throw and a skip in a park, all right? Just let me lay it down.
When I'm talking, you do not talk over me. You understand that?
No.
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
Yeah, it
3
is.
years.
Oh, no.
Well, you're the one that's elected to go with the jury trial, so you keep on saying it's only 3 years. That's fine. All right.
You try to give me 2 of it anyways. Might as well go to trial.
Okay.
I swear, I'm getting me a jaywalking jank and I'm gonna go in there, man. You know, I don't care. It's 3 days in jail, Your Honor. I'm representing myself and taking this jank to jury. I wasn't jaywalking nothing, man.
You understand, and I've told you several times now, if you represent, you will be detrimental. It will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
It is my opinion, and I'm strongly advising you against it. But you understand that in my opinion, if you represent yourself, it will be detrimental to your case.
Everybody's entitled to their opinion.
Okay? But you understand what I'm telling you.
Touche.
All right.
Touche.
You understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. You understand that?
Yes, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Oh, can I get a few minutes? I use the bathroom anyways.
He's just playing us all now, Your Honor. Can he get a few minutes to think about it? He's got to use the bathroom anyway, man. Come on!
A few minutes for what?
To use the bathroom, think about it. Make sure this is what I want to do.
Oh, no.
Take him to the bathroom.
I'll take his ass to the pisser now. This guy, man, he's built different.
Can I say something real quick, Your Honor? I ain't getting that opportunity to use the bathroom. Your officer won't allow me to come out the cuffs. I don't know how I'm supposed to. I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm just kind of obnoxious. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The
So
deputies and the transport officers are in charge of your
So
security of this.
how I'm supposed to use the bathroom in
Sir?
cuffs? How I'm supposed to be able to wipe myself in cuffs?
All right.
If your officer refused to move the cuffs when I was locked in the cell, I'm just trying to use the bathroom. I need to use the bathroom before we get started, sir.
I mean, he does have a pretty strong point. How are you supposed to wipe after a deuce? Put the cuffs on, man. It's damn near impossible. From back to front? No, sir. I'd rather walk with it on me. But, you know, I've been in situations like this. If you really have to use a bathroom like that, they'll uncuff you. Take you back to the holding tank and let you do your thing in there with all the other inmates.
Yes, sir.
What's the issue with him?
I was never asked to remove the cuffs.
She was, man. You know I had to use the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right,
so I can
let's
wipe.
get through this and we'll talk about your bathroom after that. All right. I advise you that you're charged with an assault of a corrections officer as an inmate at the correctional facility. Maximum penalty, as we've said, is 36 months in prison. Now, the issues that present themselves with regard to you representing yourself, obviously, is a logistics issue since you are incarcerated. The shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of assault on a corrections officer and is an inmate incarcerated for offenses of violence.
So I'm going to make a finding that you pose a security risk to this courtroom. So the shackles on your legs are going to remain there. Now I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your closing arguments from counsel table. Now you can stand up at that table without your legs being seen because for the record, there's a skirt or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
All right.
So the findings here are that the defendant is extremely violent. He's in there for assaulting a correctional officer. So the shackles are staying on because he could easily just run over there, jump, and assault the judge. We've covered cases not too long ago of defendants doing that as well. Never forget that when the same judge that was attacked came back to smoke him in sentencing. Go run it back if you ain't seen it. But I completely understand why the courts want to keep someone like him shackled. He is kind of maniac-y if you were to ask me.
I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand? And I've said to you already that the state of Ohio is represented by a competent, experienced trial attorney, and that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. The rules of evidence and rules of procedure, even if you don't know them, will apply to you. Do you understand that?
Yes, sir.
I cannot assist you at all during the course of the trial.
Yes, sir.
You want to again understand that this is not a license for you to abuse the dignity of this court.
Yes, sir.
There will be no appeal for ineffective assistance of counsel.
Okay. Yes, sir.
Again, how old are you?
38.
How far did you go in school?
Dropped out.
So are you able to read and write?
Yes, sir.
Do you have any prior experience in representing yourself?
Not representing myself. I've always had good dialogue with my attorneys.
Okay. Do you have any prior experience? Your prior experience in the legal system?
Just being charged with stuff.
Okay. You don't have any formal training in the law?
No, sir.
And you have no mental deficiency or conditions that would interfere with you understanding what's going on here today?
Not that I'm aware of. Debatable,
though. Now tell me once again, is it your intentions, is it your desire that you want to proceed in this trial representing yourself?
I'm pretty sure.
No, you got to be certain.
Man, this judge is giving him every single chance he could possibly get to get that attorney. And honestly, man, it's making me think twice about it my damn self. Kind of like them guys at the casino trying to get me to get those damn players cards, man. I don't want one. I ain't never getting one. It's just 3 years.
Why don't we do this? Mr. Jones? Let's allow Miss Martin to represent you, and if something happens and you can change your mind later. It's easier to go that way than to go the other way. You can't have it both ways. What's that?
Use the bathroom, please. I really gotta go, sir. I just need to use the bathroom. I'd be a lot more focused and stuff. I really gotta go.
All right, Rhodes, take him to the bathroom. I'm not going to go over this with you again. You have this one last opportunity.
I understand, sir.
All right. All right, we are back on the record in the state of Ohio versus Aaron Jones. Mr. Jones, you've had your second trip to the bathroom now. I take it everything went better?
Yes, sir.
All right,
yeah.
you have in front of you a form called waiver of counsel. I've gone over with you all of the elements of granting that waiver. Do you still wish to proceed as your own counsel?
I need to get some counsel. I need real counsel. I talked to my family. They was talking about hiring a lawyer. I thought it was a little more cut and dry. I had a little more confidence in Miss Martin in that. And just at this point in time, I'd rather just wait on my family to get a lawyer for me.
But that's not going to happen. This case is proceeding to trial today.
Myself done.
You want Miss Martin
No,
to?
I don't want her near me, around me, or nothing. She can.
All right, sign the form in front of you. All right, Ms. Martin, you'll stay behind Mr. Jones as standby counsel.
There you have it. There's another prime example if you think you can just do what you want in the courtroom. Get a continuance and say you want a paid attorney now. Nope, not today. The conductor's already started the train. There's no stopping it now.
That's your signature, sir?
Yes, sir.
And you read this document?
No, not really.
All this just
Why is Miss Martin?
frustrates a courtroom
I'm making her
dramatically.
a standby counsel in case there's an issue. She'll be in the back of the courtroom.
I don't need
Mr.
no
Jones, I
help.
don't care what you want with regard to that. I'm following procedure, and this is what we're going to do. Read the form, please.
The whole reason.
Mr. Jones, read.
Of representing myself was because I didn't trust the lady. That was the
Okay,
whole purpose of
she's
that.
not.
But
She's
she's still here and attached to my case. That's the
She's
whole
removing
purpose
herself-
of removing her was for that. Was for me to be able to represent myself.
You will be. Sign the form.
This
Read
form
it.
was already signed. You
All
already
right,
seen
read-
my
read-
signature. You already
I'm sorry,
asked me
I
my
misspoke.
signature. You see my signature was on that sheet. You already seen it was there. What are you talking about?
Mr. Jones, read the form. You
Bro,
said you
I already
didn't read
signed
it.
it, man. It's cool. Go ahead.
Read the form. Are you able to read and write?
Sometimes. Depends on how many pictures are on.
You done?
I ain't read it. I
get
already
the form.
signed it. We already went over it. It's cool.
All right, the court will make a finding then, sir, that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and the court will accept that. Ms. Martin will stay in the courtroom as standby counsel. Other than
I'm
that, are we
objecting
ready
to
to...
Ms. Martin is standing by counsel.
Mr. Jones, I'm going to tell you one...
Counsel.
Mr. Jones, I'm going to tell you
I'm not
what...
allowed to object. I'm my own counsel now. I'm allowed to object, ain't I?
Then you say the word objection.
I did. I said I object.
What are you objecting to?
I'm objecting to Ms. Martin standing by as counsel. I'm representing myself. I'm objecting to having her here. I don't trust her. So that's the whole reason of me releasing her was to represent myself because I didn't feel confident with her abilities, nor did I feel confident enough with her not working with the prosecution in order to help lay down and obtain a conviction. My removing of her was based on...
Stop.
The defendant just don't want to hear that lady's name next to his in any way, shape, or form, Your Honor. So just leave her out the equation. It's just going to keep going back and forth like this. Send her home and let her have the day off.
Your objection is overruled. Ms. Martin will stay in the courtroom as acting counsel. Standby counsel, sorry.
And ladies and gentlemen, even though it doesn't show it, the jury, if I were to guess, comes out and all that good stuff. But the narrator to this video said that he got the 3 years added to his sentence consecutively. So he's going to have to finish that 14, like I said, for the aggravated robbery. Another 4 years on that, and then do the 3 for assault in the CO. Prime example of what not to say to a judge before sentencing. And how to trick your time up in prison perfectly. But that's a wrap, ladies and gentlemen, and I do apologize. Yesterday I made a post probably a little prematurely. Should have checked the weather because today, believe it or not, is Memorial Day, and I promised y'all a cookout with Bobby, but we got thunderstorms, flood warnings, and you don't want to ignore those over here in East Tennessee. Next thing you know, you'll be floating down the river. But stay tuned, I do have a lineup of exhilarating episodes coming your way this week. And of course, the only way to do that is by hitting that notification bell, setting it to all. Until the next time though, as always, y'all be easy, be safe, and stay free.